All set.
All right, ma'am, come on over here. Don't step up here. Step up here. State your full name for the judge.
Jerry Lynn Peterson.
Thank you, Ms. Peterson. All right, Ms. Peterson, we have a fugitive complaint refiled against you. It's the same thing we talked about before. They just refiled the warrant, so I'm going to discuss the case as though we are hearing it for the first time. So a complaint's been signed, and you have been arrested as a result of an outstanding warrant for your arrest issued by the County of Clark in the state of Nevada for the criminal offense of harbor, conceal, or aid a felony offender. The above state has asked that you be returned to that state to answer the criminal charges which are pending. You have the following rights. Number one, you have the right to be represented by an attorney of your choosing at your expense. Since the issue of extradition is a civil matter and has no bearing as to your guilt or innocence on the criminal charge, this court cannot by law appoint an attorney to represent you. Number two, you have the right, before you are returned to the above state, to require the governor of this state to issue a warrant of extradition, which will result in you being returned to the state where the criminal charges are pending pursuant to Arizona Revised Statute 133847 and 133848. You will be turned over to the state for extradition if the governor issues this warrant. If you cannot post bail in the amount set by this court and the warrant has not been served upon you within 90 days from today's date, you will receive a copy of the fugitive complaint. If you wish to present evidence that you are not a fugitive from justice, the judge of that court will set the matter for a hearing. Number three, you have the right to bail during these proceedings while awaiting the issuance of the governor's warrant of extradition, unless the offense that you are charged with is equal to a capital offense where the proof is evident or the presumption is great. Once the governor's warrant is issued, you lose the right to bail. If you are not in custody when the governor's warrant is issued, then you will be reinstated and taken before a judge of the Superior Court. If you cannot pay the bail amount that is set, then you will remain in custody until the governor's warrant is issued, which could take 3 months to occur. Number four, you have the right to test the legality of your incarceration in this state by filing a petition for writ of habeas corpus in the Superior Court of Arizona. Again, you may hire a lawyer at your expense to assist you in filing the writ, but this court cannot by law appoint an attorney for you. Should you choose to, you may bypass the formal extradition process by signing a waiver of extradition. The waiver only means that you do not wish to fight the return to the state. It has nothing to do with your guilt or innocence as to the criminal charges. If you do not sign the waiver, then you are giving up the rights that have been explained to you. You will still receive a copy of the fugitive complaint, though once it is filed, after you sign this waiver, the above state will be notified to come and return you to the state. This will occur within a reasonable period of time from when you sign the waiver, and you will be held in custody without bond until your return to the other state. If authorities from the above state do not come and get you within a reasonable period of time, then you may file in the Superior Court a petition for a writ of habeas corpus to seek your release. If you have local charges pending against you presently, then you will not be returned to the other state if you sign the waiver until the local charges are disposed of. There are no local charges, okay? Do you understand what I explained to you like the first time? So you have the right to waive the extradition process and sign the forms that the detention staff has there, or you can have the governor issue the warrant for you.
I did paperwork down in Globe when I was down there.
Okay.
And I signed the papers where they were sending a letter to the governor. They released me on my own recognizance, and I got to go home.
Understood.
And I don't understand why work in here right now.
Well, let me explain that to you. So the Nevada Clark County found out of your release, and they reissued the warrant. So that's what happened since then. They didn't want you released. They wanted to come pick you up. So they when you released, then because I know you signed the papers. I was the judge you talked to the first time. So they were notified and they were on their way. The process was starting for them to come pick you up. But when you were released, they stopped and you were given a court date. But then they refiled the warrant for you. And that's why I'm seeing you again, basically on the same thing again.
So signing the paperwork for the extradition didn't matter, right?
It did, but you were released, so it starts over because of your release. So now we're starting over. You have the ability to sign those waivers, and that means that Nevada will then be notified that you're waiving the extradition process, and they'll plan to come and pick you up. If you don't sign, then you'll be held in custody, and it forces the governor to get the governor's warrant.
Part of the reason of me having to get out is my mom's really sick.
Okay.
I have a little sister with Down syndrome. If anything happens to my mom, they'll put her in a home. I have responsibilities. I have a job, which I probably don't now because I was supposed to be back to work this morning at 9 o'clock.
Yeah.
I didn't get to call them or anything.
Okay, so I don't know about those circumstances, ma'am, and I apologize, and I can sympathize with the situation.
So I was released on my own recognizance just so I can turn around and get arrested again?
Well, that's what happened because the state that had the warrant for you refiled the warrant. So the yes is the answer to that. So if you want to expedite the process and avoid going through the governor's warrant where you would have to wait for a period of time, then you sign the waivers. If you don't want it.
I did the waiver to where they were sending a letter to the governor, and that's why she gave me bail.
Okay, you don't have to, ma'am. I mean, I don't want to argue with you. So I'm telling you.
I'm not understanding all of it. I know what.
Because
I just want to get it done and over with as soon as I can.
Okay. When I try to explain it to you, ma'am, you don't listen to what I'm saying. You're interrupting me right in mid-sentence. So I know that you signed the waivers. I was the judge the last time you signed the waivers. So I know that. What is different is when you were released, the state of Nevada found out about your release and reissued the warrant. So that's why you were picked up again. That's the only difference from the last time that I spoke to you versus this time. Okay. I know that you signed the waivers last time, and that's why the process was starting for them to come pick you up, but then you were released. So they can't come and pick you up if you're not confined. They don't know where to go. They don't know where to pick you up, and you probably don't want them to pick you up at work or home, or because then it's an absolute inconvenience. Here, you know what the process is.
Yeah. Then they're going to take me back down to Globe, right?
I don't know. That's up to the detention staff. You can ask them, but the release, it's either that. So if you're wanting, ma'am, if you're wanting this to get over and to get done with, the shorter period, and I'm not trying to convince you of anything, but if you waive the governor's warrant where they have to get a warrant for you through the state of Arizona, that's a longer process. The shorter process is like you did last time, and you sign the waiver, then Nevada knows that they can come and get you. But what was the difference is you're released on the charge.
Okay.
So you can still choose whatever you want to do. But if you're telling this court that you want to do whatever the quickest thing is, then I can tell you getting a governor's warrant takes longer than signing the waivers and notifying that agency to come get you. I'm not trying to persuade you to do one way or the other, but that is the quicker process.
Okay. I wish he's going to get to stay here with you guys.
So do you wish to sign the waivers, or do you wish to? Okay, then the detention staff will present those to you.
Judge, is that sufficient for viewing?
It is, yes.
All right. So Signature on the top line, print on the bottom line.
Okay.
We gotta do
gotta
it 3 times.
Turn it this way.
Go ahead. Print on the bottom. And again, signature on the top line.
And are these all three the same copy?
Yes, ma'am.
Can I get copies of these because I didn't get anything last time?
Okay, and print. And again, signature.
Okay. What? I'm a little bit backwards sometimes.
Okay. And print below it. Okay. Judge, this time all 3 have been signed.
Okay. Ma'am, do you have any questions?
I just basically, so signing this one is hopefully they'll come and get me soon, right?
They'll be notified to come and get you again, and I know that they've been in contact with the detention staff at the sheriff's office, so they're eager to get this going as well.
Okay.
Okay.
I appreciate it. Thank you.
You're welcome.
Thank you, Judge.
You betcha.
I'll be over with the paperwork shortly, sir.
Okay, and I'll have a release order with a bond on this one too.
Okay, thank you.
Okay, you bet. Bye. set up there.
Okay.
And if it gives you problems, then we'll just go to the handheld, but hopefully it,
Oh, I think I should be able to, if it's working okay.
yeah.
Yeah, I just gotta remember which one she makes me click on. Oh, 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 no. Oh, here it is. I gotta go back to my notes, I think, go to, I know it's one little spot up here that I click on, I can't
You
remember.
know, just, you clicked on here, right?
No, oh, I didn't even notice
Yeah,
that was
close
there.
all of those.
Oh, okay, I actually brought it up the old fashioned way.
Yeah. No,
No? Oh,
that red one. What does it say? I can't.
Liberty Recorder.
That's what we want, right? Not player. Recorder.
Recorder, okay. And then I got audio. No?
I think you just start it. No, so close, you did
Stop.
something there.
It says
So close it
stop.
all again, just close it all again.
Is it?
Because you clicked on stuff that changed it. So let's go back to open it again. Let's wait for it to open. And, well, I see what you're saying, so it doesn't have a way to start.
Yes, it does. I gotta go get my notes to remind me. I have it, I do. Hold on a minute.
Might be what you said, it might be the audio or something, but I don't know.
Yeah. Yeah, she clicks one more spot up
Okay,
there.
yeah, something up there.
And I don't remember what she told me. And I know I have it in here. Liberty Recorder. Okay. And then Liberty Recorder, it's in red, yeah, okay. White page, new.
Okay, so there it is. So there's the white page on the left.
White page. Ha!
There it is.
We're in. All right. Should I let her in and then?
You can go and start it and then just, so that way you don't have to come back in, you can just send her in. Hello there. You can have a seat anywhere here. How are you?
I'm all right.
Okay. All right. So we're on record. I'll go ahead and call the case as case 2026 PO 19. This is a petition for an order of protection. The plaintiff, could you state your name?
Tabitha Gans,
Thank you. And you're filing it against who?
Arthur Decker.
Okay. I need to administer an oath to you, swearing to the facts and any testimony given today. If you'd raise your right hand. You solemnly swear or affirm that the testimony you're provided today and the information contained in this petition to be the truth, the whole truth, nothing but the truth, so help you God, or so do you affirm.
Yes.
Okay, thank you. The relationship between you and Mr. Decker?
We are past partners.
Okay, so you used to be intimate partners that lived together?
We were engaged
Okay.
until 2 weeks ago.
All right, so you lived together, you were intimate partners, and you're now broke up?
Correct.
All right. So that qualifies for the order of protection, and then I've reviewed the information that you've listed here. It indicates that, and I'm aware, that there is an order of protection placed by the defendant in this case against you that was granted and heard and remained in effect.
Correct.
Prior to that hearing, but after the issuance of that order on 1/15 of 2026, he had called you at 8:08 p.m.
Correct. I did not answer.
Okay. And then after the hearing that we had just a day or two ago, he called you today at 12:44 p.m.
Correct.
Okay. And you know that by recognizing his number?
Correct.
Okay. All right. So orders of protections work one way. They're one-way streets.
Correct.
So it's not a violation in his order to call you,
I'm aware of that.
right, but if you
However,
respond and talk.
I am well aware of the fact that if I respond, even if he initiates contact, that is reason enough to have me thrown in jail. And since I've been saying from the very beginning, Your Honor, the only reason he did this is to try, this is the only way he can still mess with me. Other than that, we don't have kids together, we don't have any property together. And if he truly wanted no contact and he fought to keep the order in place, why is he still reaching out to me and trying to contact me? There's one reason only, to try to get me in trouble. And
So,
I feel like I need this order of protection to protect myself.
well, so let me address that. So you're exactly right with everything you said, except what we presume to know his purpose, okay? So I'm not saying that's not what's happening, but we don't know that that's why he's doing that. But it's very likely that could be, and you're
Yes.
doing the right thing by not answering, not responding, because when you recognize it.
Yes.
But for an element of harassment,
Yes.
it has to be something besides a phone call.
However, Your Honor, he knows that trying to engage contact with me would get me criminally prosecuted.
It could be
And-
reported, you know, like what would happen if that, and you responded or answered, and if he called the police would investigate it, and you would say, here's where he called me, I didn't call him, and then the police.
It still doesn't matter. The law is the law, and
I
the
know.
book gets thrown at me, Your Honor, and he's
So-
well aware of that. I'm still on probation, and that would be enough to get me sent back to prison.
Can you block it?
I probably could, yes.
You can block it.
He knows where
I'm
I
telling
live,
you,
though,
you
now.
can block
Yeah,
it.
he knows where I live. He used to
Okay.
be my CPS caseworker. This man intimidates me. He's beaten the crap out of me before. Neither one of us were perfect in our relationship, but he is much larger than I am. He knows where I live, and he's continuing to call me. I feel personally threatened because of the criminal charges that could go along with that.
All right, so Mr. Decker, I can't take his ability to call anybody that he doesn't want to. Here, the examples that you're talking about are not what we have in front of us. If he comes to your house, then you tell him to get off your property, because and you don't want him there. That would obviously be an exception to something. You can't communicate, or you can dial 911 and have the police come and tell him not to come onto your property, okay? Because that's your property. You have the right to possess that. You, in this case, you're talking about it, you're right on that page and all that thing, that if you respond, you could be charged. So you're doing the right thing. Now, I can't say that he can't do that. I can't say that he can't call you because you don't have an order of protection against him. I know that's what you're asking for, but the elements of harassment aren't because it can't be sustained that he's calling you, okay?
That is harassment, though, Your Honor. We have nothing. Anything he might have had to say to me could have been handled yesterday in court, or through Tony McDaniels, who was acting as the mediator between us prior to me getting my belongings from the house. He knows that there are other ways to reach out to me. However, he also knows, because he reads the paperwork, he knows the second I answer that phone call, whether it's by accident or not.
Right. Here's what you can do. So, again, the court, because you're not the first one to come to the court to say, look, this person's calling and contacting me. Here's what you can do. Here's the direction I've given to many that are in the same position as you. You can call the police. I know that that's not your favorite thing to do, but since you can't talk to him because of that order, you can tell the police to tell him to not communicate with you at all whatsoever. That will cover phone calls, text messages, in the grocery store, anywhere. And then if he violates that, once that's been made, that statement's been made, that's called a declaration, then any violation of that, you can come right back here with saying, he's calling me. But what you would have is you would have a police report that says they are following through with your instructions and notified him that he's not to communicate with you whatsoever.
So there's no protection for me, basically?
I just told you the path.
Yeah.
I can't bend the law because of the situation. I don't like the legislation where it doesn't say they're two-way streets, just so you know. Me personally, I don't like that when somebody can get an order of protection, that it should prevent both parties. Unless there's a reason not to. A lot of times people come in here and they have bills. They're still paying my bills, so I let them text message only for the bills only. I just did one of those yesterday.
I don't
We
do
don't have any of
that.
those.
That
We don't,
man scares me.
I know, but I can't change the law. It's not that I'm picking teams. I can't bend the law the way it reads. I can give you a path, which I just explained, to get the court to be able to work for you.
So it just makes him more pissed off. It's
Makes
really
him more?
good. Yes, of course.
Well,
You
do
call
you care if he's
police.
pissed off or not? Or do you
If
want to?
there's no
do you,
protection
you're
order
talk-
in place,
Go ahead.
I do, because then
Go ahead.
if there's no protection order in place and all I do is make him angry,
Do you want an order of protection?
I do.
Then do what I just directed you to. So it fits the law. I have to do it by law. I can't bend it. So the way to do it is, it might upset him. If it does, that's his own problem, okay? But if he communicates with you one time after the police notify him, then you can come right back here and you'll have the support of a police report saying they told him not to talk to you, and that you showed the call, or you showed where he sent you a message, or whatever it is that happened after that, and then you can come get the same order that you're asking for here. But since that's not in place, that declaration's not there, it can't be used for that. I understand that it's not good because he's got an order against you. Why is he calling you, trying to entice you or bait you, or whatever that purpose may be? Or he's remorseful and wants to try to, doesn't matter, you can't respond. So don't fall into that. You're doing right. You got all these other things at probation. Don't fall into it. If he really wants to talk to you and wants to do anything besides bait you, then he can come quash the order. And he hasn't done that. So it might be what you're saying, but what the court can't do is somehow make him simply calling you fit that, okay? So the way we do that is we make the declaration. Use of the law enforcement, because you can't talk to him. If you could talk to him, I would say just tell him not to communicate with you at all whatsoever, which I tell many people that come here. Here's the difference. When relationships go bad, the two try to work it out, to some point. I'm not saying that's what's happening now, but there was a period that there was a try to work out part, right? Well, the court can't all of a sudden say, boom, that's harassment. No, you guys were trying to work this out. Same with a business deal. Bad business deal, bad business deal. Once it becomes so bad that one or the other party doesn't want to have a discussion with them anymore, they have to make that declaration. I don't want to talk to you anymore. I don't want to communicate with you at all by any means anymore. Once that happens, then if they continue to just try to talk to you, it doesn't even have to be cussing, yelling, screaming, just trying to get a hold of you, talk to you. We have a violation of that, and then we can proceed forward. The court can help you, but it requires that notice to the person.
It took me months to get the courage to leave him. He physically scares me.
Okay. Well, if
And
this
I
were,
just feel like this is just gonna anger him more. He has personal knowledge of my home, my life, my everything. Again, he was my DCS caseworker.
right,
So he took advantage of his position in the
Well,
first
if
place
you
in
wanna
order to
talk-
get to this relationship.
did you talk to his boss?
He no longer works for DCS.
Okay.
But do you see what I'm saying? He has used his authoritative power from the very beginning of this relationship. And I don't, he whipped my ass so bad, and I'm terrified of him.
Well, so even if this was granted, it's paper. It doesn't stop bullets, knives, or any of the other concerns that are there. You still have to use your precautions, okay? So that's still in place. It just is a tool to help with the criminal side of things that occur. So even if this granted, it wouldn't provide you the relief that you're looking for with those concerns. It's a piece of paper.
But it would guarantee he went to jail if he ever touched me again.
Guarantee might be a little strong, but if this issues any violation of the order, is an arrestable offense. You're right. But for me to issue the order with these circumstances, you need to get him to know that you don't want to be communicated, if that's what you want, whatsoever anymore. So that the path to that is leave here, let the police know that you're not allowed to talk to him, and that he continues to get a hold of you, and you would like them to deliver the message to him. Here's his phone number, and please tell him not to communicate with me at all. And you can say call, but then that means, can he text? Yep. Can he see you at the store? Yep. If you don't want anything to do with him, don't communicate with me at all whatsoever. Okay, so that's the language you want. Make sure the law enforcement reports it. I need you to communicate with me whatsoever. because I don't want him to come up to me in the store, I don't want him to text me, I don't want him to send me a letter, any of those things. So that's the course. Go ahead.
After I do that, then what type of paperwork will I have stating that I did
Yep.
that?
So hopefully what would happen is he doesn't do any of that. But what you can do in the meantime, as soon as that police officer is done taking the report, tell him that you would like to get a copy of that report. And so they'll tell you, get it from the records division, so you call that date. It won't be ready because the officer still gotta write it and all that. But once it is ready, they'll tell you, you come and get it, and now you have it. So if there's a violation after that, he calls you again, texts you again, or sends you mail or something, then you come here, here's the police report that I made on this date, here's the phone call or text message or whatever happened on this date, Judge, I need an order of protection granted. Does that make sense?
Yeah.
So that's the route that it needs to take steps, because I can't make the law fit just because he's calling you, because you haven't told him not to. Okay. I know, the
It
order,
should
you would
be
think the order,
implied.
I know, so that's where I talked to you about, I wish orders, personally, that would, when somebody gets one, that it prevents both parties, but it doesn't do that. I'm not the legislator, I'm not the law writer, I'm the one that has to put it in play. Okay, so we vote on those things, but that's what it is now. Okay, so that's why I can't do that. Trust me, you're not the first one that comes in frustrated with how that is, so here's the way to make it work. And then hopefully what happens, you don't have to come back, that he'll listen to what the officer tells him. And then you can show him the calls, here it is, and here's the order, I'm not allowed to, here it is, and they'll ask him, why are you doing this? And he'll have to respond to that, whatever he says, I have no idea. But then, from that point on, shouldn't have any more. If you do, you just come back here. On this statement thing, you put in here, on this date, I made a police report, here's a copy of the report, Judge, and here's the phone calls or text messages or what, if it does happen. If it doesn't, we won't see you back here, because you'll get that message. Does it make sense? Okay, so, for the causes that you have here, I'll have to deny it because of what we discussed. I've given you the path to make it work. I would suggest you
If I would have put in there that he's been physically abusive with me in the past, would that have made a difference?
well, it depends how long in the past. So these are good, you have to do an incident within a year. So,
Yeah, just about 4 months ago, he beat the shit out of me for 3 hours. 3 hours nonstop. He's a big man. He picked me up and threw me around like a rag doll.
So those are different facts and circumstances. They're not introduced. So I would look at those. You're raising your hand, doing an oath. You'll have an opportunity to be heard on it and refute, say yes or no. And if was a police involved in it at all, so that again, we would
I'm
come to.
scared of the cops.
Okay, well, so then all I have is he said, she said, me or another judge, as he said, she said allegations because nobody reports it to the police, which is an error and a mistake. I always project that from a court, because who am I to give weight and credibility to when there's not anything of evidence besides somebody saying this happened, somebody saying no it didn't, and there's no evidence. So you put a judge in a bad position because of that, to make a ruling. But it comes down to the preponderance of evidence, like we did when we had the hearing before. So, does that answer your question?
Yep.
Okay, so do you want to wait around for the denial, or does it not matter? Okay, but you know what to do from here, so if you decide to do that,
so I'll just go piss him off with no protection orders. Sounds great.
you can do nothing, or you can do something, and whatever happens on his behavior is up to him.
But I'm the one who pays for it. Thank you, though. Thank you.
set?
Yep.
Thank you.
Hello, this is John Reed.
Hi there, this is Judge Garvin, Payson Courts. How are you?
I'm good, sir. How are you?
I'm doing good. So I got to start a record, and then I got to explain a mishap that happened with my clerk. So case number 2025 CT 3898. This is the state of Arizona versus Christina Etter, and appearing telephonically for the defendant.
Attorney John Reed.
Thank you. All right, Mr. Rude, what occurred is I always give a tolerance of about 10 minutes. The date is the 29th of January, and it is now 3:43. I normally give a 10-minute. The officer did not show, and in a review of the case, I found that the officer did not get service of this hearing. So I'm posing a reschedule for this since the court made an error on that. And I wanted to get your say-so on it.
Well, Your Honor, just my position is the defense is prepared. I mean, obviously this is no fault of my clients or mine, and many things happen, I understand, but essentially, I'd argue, I guess, that, he has a right to have a prompt hearing, and essentially that can't happen now, or my client, I'm sorry about that. And if there's any way the court could dismiss the case, because it's a real important case to her for a lot of different reasons, just employment-wise, and I wanted to even see if the court would even allow a change in the statute to a finite resources statute or something to that effect. But I mean, I'd ask if you could please dismiss the case. I mean, it's not of our doing, and she's got an employment problem here, and she can't work essentially because this is all happening, and the delay basically is money. In
Yes.
the end, she can't work. So
Okay, and so the way we'll tailor this is I'll put an objection in for what you're saying to the court continuance. I'll note the objection, and maybe if you wanted to, you could progress into an appeal on that to see if it will qualify for another court to review it. The other thing I wanted to pose is, there's kind of a rule of thumb at this court, and I don't know if you've already spoke to your client about it, but her speed is within the tolerance level for traffic school, unless she's not eligible. I don't know if she's already attended it or not. You certainly could pose that to her, and we could issue that, give those instructions to your office to have her complete that, or we could send it to her, or if that's an option for you. So.
Well, so is what's happening, so the court's going to reset it either way, is that basically what
Correct. We're going to reset it, and because I don't think that it's just for to give the trooper an opportunity to give testimony and do it. So it was a court error. So I'll note your objection for a record. It can be viewed on an appeal if you wish to pursue it to that extent. On you were prepared and ready with your and ready to go, and with all the ramifications that can happen to your client, and they could review that component, but it won't affect as of now us resetting it. But there's also the ability, I don't know if you spoke with your client on it, about defensive driving school.
So, Your Honor, can I ask a general question also? If, let's say, the officer is amenable to even amending the statute, is that something the court would allow if I were to talk to the officer and maybe do a stipulation?
Yeah, so what they could do is you can have a discussion with the officer ahead of time. What the court does not want law enforcement to do is become judges. So so you can have that discussion. They can request that before we actually start the hearing. If we have another date and we start the hearing, and then they give a cause for that adjustment, and they could say that they spoke with you and that you feel that this would be an appropriate enforcement action. It kind of gives them the judicial authority to do that. Here's the opposite end of that. Here's what this court won't allow law enforcement to do. Sometimes they write a speed for, let's say somebody's doing 30 over, but they only write it for 20 over. The statute's the same, but boy gosh, if they take them to court, they're going to write that actual speed. I don't let them consequence a defendant for exercising their rights, so I got to be careful. I protect it on both sides of that sword, if you know what I mean.
Sure. So if we did, let's say, come to a resolution, let's just, for fun, just call it that.
Yep.
And then could I draft a stipulated motion and send it to the court for your consideration ahead of the hearing? Is that better? Or just to appear at the hearing and say we've talked about it and we can do it on the record? If he's amenable to that.
Yeah.
And a lot of courts just let us do it on the record. I mean,
yeah,
it's not a huge deal, but
the record is fine. Yeah, so you don't have to draft anything to take that time. But if we rescheduled the hearing, appear it again, and the officer or you, the combination of such, gave that on record, that'd be fine with the court.
okay. Do you, just real quick, the officer's name on this? Do you have? Does the court have a contact for him, or
I don't have.
you communicate with him?
Yeah, so I don't have direct contact. We would call the DPS office and ask for Trooper Eldridge. Yeah.
Okay, all right. I'll just go that route. When are we going to reset for?
Do you want me to give you that date now, or do you want me to just send that to you?
They can send it, whatever's easier.
Okay, it'll be a minimum, no less than 30 days. So give you an opportunity to get some stuff done here.
Is it possible for my schedule? I have a nightmare schedule for
Yep.
the last 2 weeks of February. To be honest, everything's piling up on me, and could it roll out to early March?
Yes. I'll do that for you as a kind of a
So
compensation. Yeah. So somewhere in the first couple of weeks of March is okay.
Yeah, and Judge, I want to just also say to you that I'm not trying to, I'm not placing blame on, hey, I get it, things happen, so it's just, I have to just make a record because God forbid, somebody were to look at the record, let's just say, and wonder why I didn't take a position in favor of their position, you know what I'm trying to say, so.
I do, and I don't take it any other way, and that's why I wanted to kind of formalize what you were saying. I'll say it as an objection that benefits for you to do to convince your boss or to proceed later. And I take it it's an error that I'm owning it in terms of our court not notifying the trooper. So you're exactly right with everything you're saying. You're ready to go. You guys are prepared. It just doesn't change. It's not the first time this has happened, but this is what we do sometimes. So
It happens.
yeah.
I get it. I've been doing it for 25 years. I've seen things. Everything you can imagine I've seen.
Yeah, there's probably not many surprises anymore.
No. Once in a while, and that's always refreshing because you like to see different things sometimes. But you know how it goes.
I did law enforcement for 28 years prior to this, and it got pretty routine, which is bad on the law enforcement side. You don't want to ever say routine of things because then you start getting complacent on certain things. But it was time to go and took on a different route. So.
Sure. Same with me. I was a county attorney for about 5 years, not probably as long as you were in law enforcement, but
yeah.
I learned a lot. It was it was a good job. I learned a lot, and it was definitely something I would do again if I had the opportunity. And
yeah, good.
There's no better place to learn to do it on that side, to be honest with you.
You betcha. Yeah, you bet. We just finished up a double homicide trial here. I went and sat in on the final closing arguments.
Okay.
The jury came back in within 2 hours on guilty times 2, so that didn't take long.
Sure.
All right, sir. All right, so we'll get that.
No, that's good.
Yeah, we'll get that date set out to you, and it'll be sometime in March.
Thank you, sir. And everyone be safe. Have a good weekend.
Thank you, you do. Bye now.